Contract of guarantee, and its characteristics. Definition: a contract of guarantee is a legal agreement in which one party, the guarantor, promises to be responsible for the debt or obligation of another party, the principal debtor, if that party fails to fulfill their obligation to a third party, the creditor. This type of contract is commonly used in financial and commercial transactions to provide additional security to creditors. Example: a request B to give Rs. 50,000 to C and guarantees that C will repay the amount within a year. If C does not, A himself will pay the amount to B. This contract would be a contract of guarantee. Parties to contract of guarantee. There are three parties to the contract of guarantee: a surety, principal debtor, and creditor. The person who gives the guarantee is called the surety. The person in respect of whose default the guarantee is given is called the principal debtor. The person to whom the guarantee is given is called the creditor. Characteristics of a contract of guarantee: tripartite agreement, free consent, written consideration, primary obligation, secondary obligation, specific promise, disclosure of facts, rights of surety, discharge of surety, continuing guarantee, coextensive liability. Tripartite agreement. A contract of guarantee involves three parties: the creditor, the principal debtor, and the guarantor. The creditor provides the loan or service to the principal debtor, and the guarantor ensures the creditor of the repayment or performance. Secondary obligation. The guarantor's liability is secondary and contingent upon the default of the principal debtor. The guarantor only becomes liable if the principal debtor fails to fulfill their obligation. Primary obligation. Primary obligation lies on the principal debtor. Written form. Typically, a contract of guarantee needs to be in writing to be enforceable, as per the statute of frauds in many jurisdictions. Consideration. The guarantee must be supported by consideration, which can be the benefit provided to the principal debtor or a detriment suffered by the guarantor. Specific promise. The guarantor's promise must be clear and specific, outlining the extent and nature of the obligation being guaranteed. Disclosure of all facts. A contract of guarantee requires complete disclosure of all the material facts by the principal debtor or the creditor to the surety before the contract is entered into by him. Free consent. Free consent of all parties is essential for a contract to be valid. Coextensive liability. Liability of guarantor is coextensive with the principal debtor. Rights of the guarantor. Right of subrogation. Once the guarantor pays off the debt, they assume the creditor's rights against the principal debtor. Right of indemnity. The guarantor can claim reimbursement from the principal debtor for any amount paid under the guarantee. Right of contribution. If there are co-guarantors, the guarantor can seek proportional contribution from them. Discharge of guarantor. The guarantor can be discharged from their obligations if there is a material alteration in the original contract without their consent, or if the creditor acts in a manner that prejudices the guarantor's rights. Continuing guarantee. A guarantee can be either specific for a single transaction or continuing for a series of transactions. In a continuing guarantee, the guarantor remains liable until the guarantee is explicitly revoked. Understanding these characteristics helps in recognizing the obligations and rights of each party involved in a contract of guarantee, providing clarity and security in financial and contractual arrangements.